Okay, good morning, everyone. Today we will be discussing the supplement paper for civil procedure. All right. Okay, let's come to the compulsory question. A case was fixed for trial in KL High Court. On the trial date, the counsel for the defendant applied for postponement as the defendant was absent. The reason for this absence was that his early morning flight from Kuching to Kuala Lumpur was delayed due to the bad weather. Advise the plaintiff if he can successfully object to the request for postponement and give a reason. So from this question, right, essentially it has nothing to do with the usual thing lah. It's like it has nothing to do with the what the trial procedures. The I mean the what the it has nothing to do with all your very lengthy introduction. But since it's a very straightforward question, what do you guys think? You can have your you can have your answer in the group chat. Since this is a 5 marks question, I would say it's a very straightforward question, and then you can answer without any information without any introduction. Okay, since the question is asking on the defendant's absent, okay, so it's a very straightforward question. So you can refer to Order 35, Rule 1, Sub 2. So from the sentence here, you will see if the party does not appear, the judge may proceed with the trial of the action, or without trial give judgment, or dismiss the action, or make any other as he thinks fit. So from the fact the defendant was absent, so the case for the so that the judge has the power to continue the trial. without the defendant's absence. However, you see, the reason for his absence was because of the flight. So actually, there is a case law to saying by saying that your flight reason is not a good reason for your absence. This is the case of Go Pak Hong. Tractor. In this case, actually, it's very similar to the question actually because the fact concern is that the party's absence is due to was a flight reason to Kota Baru court lah, and actually now and the court held that your flight is not it's not a good reason because that you can you can schedule your flight earlier, which is quite true lah, because it's like tomorrow is your trial, but today you only book your flight today, right? You can book it one day earlier or 1 week before lah. You can go there as early as you can now. No need to be the last minute booking now. Okay. So we go on to the question 2. Assume that the request for postponement of trial was disallowed by the court and the judge ordered trial to commence. Can the plaintiff counsel apply to the court to enter judgment against the defendant on the ground that the defendant is absent? Give reasons for your answer. Okay, before we proceed to that, right, I saw one question here. He asked, can we say that the D is not necessary to be in court during trial, which can be just attend? Okay, actually, what you say is quite true, but you wouldn't know since this is a trial. Actually, what is meant by trial and hearing now is actually totally different word. The trial is an open court. And why the attendance is required? Because somehow, let's say you have 5 defendant witnesses. Okay. So if let's say today they are going to today is defendant's case now. Let's say today is defendant's case. For the D1, they're already ongoing, like until usually the re-examination is shorter than a cross-examination. So when it is about to the second defendant witness turn, but your defendant witness is not there. Yeah. So it will cause certain level of inconvenience lah. That is the reason why we cannot say that or just attend by the counsel. What if today is your case and you don't have any witness to you don't have any witness to be examined? Yeah, it will cause certain inconvenience to everyone. Is that okay? Okay, so looking at the question B, right? The postponement was disallowed because you see, just now we already say that the question the rules of court order should be referred to this one. Therefore, the plaintiff may apply to the court to enter the judgment against the defendant pursuant to Order 35 1 sub 2. But bear in mind, this is not a final judgment. Even though the party has applied to the court to enter a judgment, it is not a final judgment because it can be set aside within 14 days by giving a good reason. Okay? This can be seen in order the D5 rule 2 sub 2. As you can see, the application under this rule shall be made within 14 days. Yeah. Okay. That will be your answer. Now, we look into C. Assume that the court did not allow plaintiff to enter the judgment against the defendant and order the trial should proceed. Before the plaintiff commences his testimony, the judge orders the various bundles of documents filed by parties prior to the trial to be marked. Advise the plaintiff on the criteria followed by the court to distinguish and mark the various bundles of documents. This one actually, this question asked before. Actually, this question has been asked before. But can you all share me with your answer? I'm pretty sure this question has been asked before. Okay, I guess this question has been asked before, but it's quite rare because it's towards a practical sense already. Actually, the bundle of documents right to be marked is you can found in Order 34. Rule 2 in bracket E. Okay, so from here, right? Actually, D and E lah. So the bundle of document, what does it mean in a trial? So in the trial, there will be several bundles of documents to be referred. The reason why they want to differentiate it into Part A, Part B, and Part C, because the Part A, you can see from the wording. The Part A, the agreed bundles will be marked as Part A. What does it mean by agreed bundle of documents? So the contents and the authenticities are agreed between the parties. Let's say your companies, let's say in civil date lah, your company search, okay, your I mean the IC of each parties lah, because the agreed bundles is where your authenticity and the contents are agreed between the parties. It will not be challenged during the trial. But in Part B onwards, the contents is likely to be challenged. Let's say if I want to do a cross-examination, I will be starting from Part B onwards. So why that is a Part B document? Because the authenticity is not disputed, but the contents are disputed. Let's say your bank statements and some invoices, because nobody will challenge on the authenticity of the invoices and the bank statements, but the contents. Let's say in a bank statement, you show that you have paid to someone, but now I am going to ask you the particular question based on the bank statement. That is the reason I found it in bundle B. But Part C document is a very, very, very interesting part because the authenticity and the contents are disputed. A very good example will be our WhatsApp conversation. The reason why? You will be challenged on the authenticity, whether the screenshot is being edited or whatnot. Let's say you found in the bundle that this is generated from your screenshot, and then you show the contents of the chats between the parties. But I but on the other hand, the opponent solicitor will challenge on certain parts lah. Yeah. The first example will be your WhatsApp conversation. The second thing will be the audio transcript, because nowadays the technology is being innovated into a certain ground lah. So let's say today you are using a voice recording over the WhatsApp, right? The audio has to be transcribed and presented in the way of transcript, let's say like a dialogue. What does A say and what does B say? So as the opponent solicitor, they are going to challenge on the contents of the transcript, or whether it is genuinely being transcribed properly. Because somehow they are not yet, because the authenticity is whether the recording is complete, the audio recording is complete, or whether the machine is a good is whether the audio quality itself is a good quality. Let's say your audio has a lot of the background noises. Yeah. So when it comes to part C, right, actually both the authenticity and the contents are being disputed between the parties. So when we are about to answer the question, right, you just have to summarize what does Order 34, Rule 2, Sub 2, D, and E. That will suffice. Is that okay? Okay, so we move to the next question. Just before the plaintiff commenced the testimony, counsel for the defendant made a preliminary objection against the plaintiff's claim on the ground that the plaintiff's statement of claim was defective. Advise the plaintiff if the defendant's counsel preliminary objection will succeed. 5 marks question. This is a typical chapter 1 question lah. Can or cannot? Actually, it's cannot because let me go and search. Okay, as you all can see, the wording here, the written notice, there must be a written notice, and it must be given 4 clear working days before the hearing. Okay, the reason why you need to give such date is that to prevent the parties caught by surprise. Okay, from the event here, from the question here, it says, before the plaintiff commenced the testimony, counsel of the defendant made a preliminary objection. But the problem is, you see whether there are any 4 clear days as per the bar counsel ruling? No, right? So this is a very clear answer. This is very clear that the defendant does not comply to the bar counsel ruling. Chapter 11. Even though you cannot remember the exact order, just say that chapter 11 of your bar counsel ruling stated that you must be the plaintiff must be given 4 clear days of the notice to raise the preliminary objection. On the fact that the defendant does not comply, he cannot raise the preliminary objection. Okay? Okay. Part E. Assume that the judge ordered that the trial should proceed. The plaintiff closed his case and the counsel for the defendant was asked to open the defense. At this point, counsel for the plaintiff realized that he had failed to put an important question to the plaintiff during the re-examination. The plaintiff wants to reopen the case and include additional question. Advise the plaintiff if this can be done. Can or cannot? Actually, it cannot, because this is the case law. Okay, I've posted in the meeting chat group. So this is the case law by saying that actually the reopen of the case is subject to the discretion by the judge. It must be used sparingly, meaning that cannot be used often. So what does it mean by reopen the case? So this is a sequence. Let's say now, actually, most of the time, I mean every time, this is the sequence of the trial. First thing is the plaintiff case. What does it mean by plaintiff's case? Firstly, the plaintiff witness, no matter it's from 1 to 100, the plaintiff witnesses will be going through in chief, cross-examination, then re-examination for each witness. So after the last witness of plaintiff has been done, is so-called that is the so-called the plaintiff has closed their case. Then it will pass to the defendant's turn. That means the defendant's case is where the defendant's witnesses will be going through the examination process. EIC, cross and re. After defendants also close their case, okay, that is the end of their cases already. That means plaintiff and defendants has closed their case. What has to be done? The next thing is they will have to file their written submission and the submission in reply. It can be simultaneously or whatnot. But the thing is, what is meant by plaintiff or the defendant's case? So when you all see the term, the plaintiff closed his case, means that the plaintiff's witnesses or witness has nothing to do. because the examination of the plaintiff witnesses are completed. Okay. Now we go on to the question 2. ABC's and Yuan Berhad purchased an artwork from Peter, which placed in the director boardroom. Purchase price is 1.5 mil, and the company has 60 days to pay the sum to Peter. In the meantime, ABC has been approached by David, who claims that the artwork belongs to him and that it was unlawfully removed from the studio by Peter. ABC decided to cancel the purchase of the artwork from Peter. Both Peter and David have now demanded that ABC should return the artwork to each of them respectively, and both of them have appointed their own solicitor to make legal demands against ABC's and Yuan Berhad. Advise ABC on the procedure it should adopt in order to avoid becoming entangled in the dispute between Peter and David. So, can you all share the answer in the group chat so that at least I will know where are you? I will know from which point you some of you might confuse. Okay. I saw one response is stakeholder interpleader, correct? Because the fact is very clear. Two persons are claiming the ownership of the artwork. Okay, so why there is an interpleader? Why there's an interpleader? Because you want the court to determine who is the rightful owner of the particular property. So if let's say A and B are disputing as to the ownership, are claiming their ownership, and you are a very innocent party, I would say, because you have nothing to do with the particular property, and now you are facing both sides conflicting version, claiming that they are the register or they are the owner, and they are about to sue you. So to avoid being this kind of embarrassed suit, right, you can apply to the court for interpleader and let the court to decide who is the owner. Is that okay? Pang filed a writ action. Okay, next question. Pang filed a writ action against XY contractor for damages arising from serious defect in the construction of a holiday home for him in Razors Hill. While preparing for the trial, Pang's solicitor asked him to provide technical drawings produced by the consultant engineer for the holiday home. The consultant engineer ignored Pang's request to provide technical drawings to Pang. Pang's solicitors are of the view that the technical drawings are essential. Drawings are essential if he is to succeed at the trial. Advise Pang on the procedure he should adopt to obtain the technical drawings from the consultant engineer and the legal principles involved. So, what will be your answer? Discovery is correct, but which order? It can be order 24 and multiple orders lah. Okay, you see, rule 3, or actually the answer is order 24, rule 7, because you are going to obtain particular set of documents. But the problem is you must get the court's leave, the leave of court. That is the reason why, although your final answer will be founded in order 24, rule 7, but you cannot escape the fact that you need to include the leave of court, which is order 24, rule 3. So when you answer these questions right, your answer must include order 24, rule 7, because this is the procedure. How can you obtain the particular set of document? But you also must include order 24, rule 3, because leave of court is required when you want to apply for a discovery. Is that okay? Okay, we move on to C. Wong, a citizen of China, lives in China, is a cash purchaser of condominium in KL, having purchased it from a developer. Wong filed a claim in Sessions Court against the developer for damages for the late delivery of vacant possession and for the defects of condominium. The developer filed an application in the court requiring Wong to provide security for costs on the ground that he is ordinarily resident out of the jurisdiction of the Malaysian court. Wong has sought your advice as to whether he can successfully object to the developer's application for security for costs. Advise Wong on the legal principles which are applicable when the court determines the application for security for cost. All right, so the question is very, very relying on the security for cost. So everyone can share your answer in the group to let me so I can see where you guys are coming from. Okay, actually, the question is about the security for cost, right? So, what does it mean by a security for cost? The security for cost is asking a foreigner plaintiff to pay a certain sum to the court as a security in the sense of like a deposit. So if let's say if anything happened, at least the plaintiff has deposited a certain sum when there is a need to pay lah. But in this case, you have to explain very thoroughly based on the chapter of security for cost. So you must make sure that your order 23 is there. Okay. Your security for cost, you must you must write out the principle because you see, this is a very high marks question. So that you must explain it accordingly. Because you must tell the examiner that, hey, Kawan, I know what you're asking, but let me explain first. Okay? Your order 23 rule 1, you have to list out the criterias how they can apply for the security for cost. Here, this is the first one, then the second one, third one, or the fourth one. You must itemize out the order 23 one, the criterias. Then you can only proceed to the next part, which is the factors considered by the court. The factors considered by the court, it can be seen in the case of Sir Lindsay Parkinson. There are few factors considered by the court under this case. And then some of the factors are whether the application is a bona fide. Okay. Second thing is whether there's any oppressive application. What does it mean by oppressive application? That means in a layman term, we say tekan, like I'm forcing you to do that. I'm forcing you to do this. This is a so-called oppressive application. And then you also have to see the stage where the defendant apply for the security for cost. It cannot be that, oh, suddenly apply. This is not allowed. Okay. So when your answer have already included order 23 rule 1, which is the criteria that allows the defendant to apply, then your second part is on the factors considered by the court as per Sir Lindsay Parkinson. Okay. Now we come to the third part. Whether the security for cost will be given. I saw one answer in the chat. I saw one answer in the chat. Okay. Cannot apply for security for cost by using reason while ordinarily resident outside jurisdiction of the Malaysia. Yes, this is precisely this is the answer. But your case, because I haven't seen this case lah. So what I usually use is the case of China. this is the case where the court held that you cannot simply rely on someone who is a foreigner as the ground to apply for security for costs. When you cannot show that, when you cannot show that he got nothing, he has nothing to pay, okay? Because actually this Le Ching Chai, right, is a very I think you can find his name in one of the accounting firm, Le Lang. Yeah, he is one of the managing partner lah. Okay, so in that case, the court held that you cannot use the plaintiff as a foreigner as the ground, is a foreigner as the ground to apply for security for costs. Is that okay? So that will be the structure. First, you itemize the criteria. Secondly, the factors considered by the court. And lastly, your conclusion, whether or not the defendant can succeed in applying for security for costs. That will be the whole structure of your answer. Because for 9 marks, actually, this is what the structure has to be now. Your introduction, your application, and your conclusion. Okay? 3. Hassan filed a writ action in the Sessions Court against Dawood for injuries suffered by him in a road accident caused by the negligence of Dawood. Hassan informed Dawood that at the trial of the action, he will claim 500,000 as special and general damages, including costs against Dawood. Dawood has been advised by a solicitor that Hassan's total damages will not exceed 100,000. Dawood wants to offer 100,000 to Hassan. If Hassan refuses the offer, he wants Hassan to be liable to pay the cost of the action if less than 100,000 is awarded by the court. Advise Dawood on the procedure that he should adopt. Any thoughts? All right. Actually, the answer is on Order 22B. Offer to settle. What does it mean by offer to settle? Actually, this is something like out of court settlement now. Because if we go on to, because let's say today A sues B and B instead of waiting the full trial to award the judgment sum, now he go and shake A's hand and say, okay, I'm going to offer you this sum. Okay, so this is the so-called offer to settle. So actually, this is a very technical part. Why? Because before the trial commenced, I mean, when the action is filed, but you haven't started the trial, right? The contract, the rules of contract applies. That means you have a certain timeline to accept the offer or to refuse the offer. That is the reason why Order 22B step in. Because now you see, he already filed an action, but now is pending for trial. So that looking to the Order 22B, you see, wait, what is the timing to make the offer to settle? Anytime before the court dispose the matter. Okay, so this one already there. And then time for acceptance and withdrawal. So where there is a specific time, you must accept within the timeline. So if there is no specific time, very good. Any time before the court dispose of the matter. But here, does any point they say there is a timeline? No, right? So when Dawood wants to offer, Hassan has the liberty to refuse at any time, as long as the matter is not disposed, which means that the judgment is given. So this is the benefit. When someone offer you, but it doesn't give a timeline, so any time before the judgment arrived, you can accept. Okay? So your answer should be based on the scenario. It is about the offer to settle, and you have to explain why there is an offer to settle, because now he wants to pay for a lower amount. You see, initially Hassan wants to claim 500,000 from Dawood, and now Dawood, after advice by his solicitor, in the view that it's only 100,000, so he wants to offer 100,000 to Hassan. That is the reason why you use Order 22B. And then the procedure, okay? Your Order 22B, Rule 2 and Rule 3, you must explain it. What does it say? Okay? Therefore, you must write out the Order 22B as much as you can, like the timing, whether or not he can accept. So Dawood, to advise Dawood, if let's say Hassan doesn't want to accept, you can nothing to do, because you didn't have a specific time for Hassan to accept or refuse. So that Hassan has the liberty and the open timeline for him to accept or refuse. Is that okay? But then, since it concerns about He's worried that, oh, if Hassan refuses, he wants Hassan to be liable to pay the cost of the action if less than 100 is awarded by the court. Then you can also quote this. Order 22B, Rule 9, Sub 2. B. If not accepted by the plaintiff and the plaintiff obtained the judgment not favorable than the term offered to settle, the plaintiff is entitled to cost to date and the offer was served and the defendant is entitled. That means each party has to bear the cost. Okay? This is a part of the conclusion already. But the foundation is on Order 22B. Is that okay? Okay. B. A plaintiff filed an action in libel against the defendant. In the statement of claim, plaintiff claimed for general damages. Although the writ of summons and statement of claim was served on the defendant, he failed to enter an appearance within the time limited to enter appearance. Advise the plaintiff on the procedural steps he should adopt in view of the defendant's default. What do you all think? Feel free to share your answer in the chat. At least we can we can share between each other lah. Okay, so one answer here. Okay, so essentially, you must write out the appearance. What does it mean by appearance? Let's say now the plaintiff commences a suit, file an action against the defendant. Okay, so upon the service, you will be given the timeline subject to the court. Because in Malaysia, we have two courts. One is High Court of Malaysia, one is Sabah and Sarawak. The reason why I say so, because this is provided in our Article 121 of our Federal Constitution. There are two different courts. Court of Malaysia, which is governing the entire West Malaysia. Another part is Sabah and Sarawak. So the timeline differs for the plaintiff enter for the parties enter into the appearance. You can see from Order 12. Number 4. Within the High Court of Malaysia, 14 days after the service. But Sarawak and Sabah, it can extend up to 20 days. Because the different timeline, so that you have to write out, okay, here, the appearance for the defendants to enter into the appearance. You have to explain to the examiner, I know this. I know you didn't say that, but I know. I let you know. Okay? So you let them, you have to write out and explain what is the timeline for the defendant enter the appearance. Okay? So according to Order 12 and Rule 4, the defendant has 14 days to enter into an appearance. But from the fact that he failed to enter into appearance, so the plaintiff can enter judgment in default against the defendant. Okay, so under your Order 13, what can be done? You see, this is concerning a defamation case because from the cause of action in libel, and this is law of defamation. It's either libel or slander. So by looking at this is a defamation suit, and he wants to claim for general damages. Whether this can be claimed. Can or cannot? Answer is yes. Looking at looking at your YouTube, claim for unliquidated damages. So that means it has to be assessed by the court. So by looking into the fact, he's only claiming for this. So yes, Order 13 says so. You can claim for the general damages. Okay? So since you already have your answer on Order 12 Rule 4, Order 13 Rule 2, and you also have to explain a little bit on the finality finality of the JID on the appearance. Because the problem is that we have to understand this. A JID is not a final judgment. It has a 30 days time frame to be crystallized. So even on that day, let's say today is June 21, the the, uh, the court has already dated the judgment in default against the defendant. It doesn't mean that the judgment in default is a final judgment. Okay, so the final the JID will become a final judgment after 30 days. Is that okay? Okay. Param was lawfully using a pedestrian crossing to cross the road when a car driven by Devan collided with him. The car crashed into another vehicle. Devan was killed in the subsequent collision. Param suffered serious injuries and want to file a writ action against Devan's estate for general damages. To the best of Param's knowledge, no letter of administration of or grant of probate has been issued in respect of the estate. Advise Param on the procedure he should adopt if he wants to commence legal action against the estate of Devan. Okay, what do you all think? Okay, we come to this question. Now, this Devan has no probate or letter of administration, which means that he dies without a will. Okay, so if Paran were to file the action, what he has to take note. Okay, so the first thing is you have to see the limitation period. Anybody knows the limitation period for the estate claim? Is provided in Section 8, Sub 3 of your CLA 1956. Yes, 6 months of upon the extraction of the grant of probate or the letter of administration. Okay, so this is first part of your answer. Parang have to take the have to Parang has only have the 6 months of the limitation to sue the representative of Taiwan. Okay, so on the fact that he has Taiwan died without any view, you have to refer to this case. In this case of Ang Hoi Ying, the the court held that you can only have the right to sue after the extraction of the letter of administration, because the letter of administration will say that who will be the personal rep for the deceased person. Okay. Okay. Before we move on, we look back to the previous question. The reason why I think I've missed out one part now. I mean, uh, just now where we stop. We stop at the final deed, because the reason why I say 30 days for the judgment in default turns to crystallize, because most of the time, right, when you want to enforce a final judgment, you must make sure that uh you did not simply use a JID to enforce it. What does it mean by JID? JID is just like a temporary, or how to say, just like a temporary judgment by saying that, okay, now this is the fault by the defendant for not entering into appearance. What does it mean by appearance? Basically, when a plaintiff sues a defendant, the defendant must enter an appearance in order to defend for him or herself or themselves. An appearance simply means that somebody wants to defend. Okay, so when a plaintiff sue the defendant, but defendant doesn't defend, that is the so-called judgment in default. Okay, so now why I say a judgment in default has 30 days to crystallize, because within the 30 days, the defendant can set aside the the judgment in default. This is provided under Order 42 Rule 13. And also, the defendant can successfully set aside the judgment in default if the judgment in default of appearance was not entered properly. Let's say you serve on the defendant's wrong address, or you did not comply on the service of the writ and statement of claim. So if there is a technical non-compliance, the defendant has the option to set aside. So within the 30 days, the defendant has the option to set aside JID. Therefore, the JID itself per se is not a final judgment until and unless 30 days has been lapsed. So what can the plaintiff do after the 30 days of the JID? Basically, is to enforce the judgment. Let's say in the recovery of some right, most of them may use the depends on the amount lah. If the amount meets the threshold, the plaintiff has the option to file a bankruptcy suit against the defendant. But bankruptcy is the very, very last resort because according to your rules of court, there are numerous ways to enforce the judgment. Let's say you're garnishing your security action, charging orders and rate of seizure and sale, rate of execution, so on and so forth. But this is provided when it becomes a finality of the judgment. By using the JID, that piece of paper, you can't do anything. And also, if you were to enforce it, you must make sure that it not only the 30 days lah, because the 30 days the defendant has the option to challenge, and also you must make sure that you have to enforce it within the 12 years from the date of judgment. Okay, because why? Order 46 says so. If you were to enforce a judgment after the 6 years, you are not only not entitled to the interest in the judgment sum, you must also explain to the court and get the leave of court to say and explain what have you done within the past 6 years. You cannot simply go to the court and say, I got the right to enforce it within 12 years. That's why until the 11 years and 11 months you want to enforce it, cannot. Okay. Feel free to post share in the chat if you don't understand particular parts. Okay. Plaintiff filed a writ action against a defendant at the High Court of Malaya at Kota Baru, Kelantan, and the writ was issued on 1st of June 2025. As the defendant could not be located despite several attempts at service, the case in court kept being postponed. On November 16, 2025, when the case came up for case management, the court directed that the writ must be served by the next CM date on 15 December 2025. And once the plaintiff on the procedural steps he should take in order to effect valid service of the writ of summons. So I believe this one comparatively is a very straightforward and also repeated us in past year question. You can share your answer here. Actually, there's a hidden trick here. You see, when was the writ dated? 1st of June. And why you have to take note? the lifespan of the REIT. So under your order 7, right, your REIT has a time span of 6 months. Okay, or sorry, order 6. Order 6, Rule 7. Order 6, Rule 7 says that a REIT has a time span of 6 months. So from the date itself, 1st of June 2025, that the REIT is likely to be expired on December. And now when it comes up to the case management, it's about to lapse, right? Because on 16 you still cannot serve. So that what does the plaintiff have to do? Renew the REIT. Renew the REIT is provided under order 6, Rule 7 sub 2. Correct. You must renew the REIT. And the case is better speedy. Because this is what does a 10 marks question looks like. If you only merely answer on the part of on the substituted service, right? You only secure half part of the answer. The full answer should be your lifespan of the REIT and what you have to do by the time before you apply for SS. The reason why there will be an SS because usually when you want to serve the REIT to the defendant has evaded the service. Okay, this is exactly can be seen in the case fact. The defendant could not be located despite several attempts at service. There are few possibilities why he cannot be located. Either he has changed his address or he wants to evade or whatnot. You wouldn't know. But the problem is when you cannot attempt the service, you cannot serve the SOC and the REIT to the defendant for few times, you have the option to apply for SS, which is substituted service under your order 62.5. Is that okay? So your first part is the lifespan of the REIT, then your renewal of the REIT. Only and after you explain the entire thing of the REIT, then you go on to your application for substituted service, order 62.5 and your practice direction, what you have to do. First thing, under your practice direction, you must give the cause to the defendant at reasonable time and cannot be back to back. It's like let's say today is Sunday, you cannot call out. Of course, you would answer. But on tomorrow, Monday, you call. After 2 days, you call again. Because back to back, he has a reason. But if there is a gap, unlikely the defense can sustain now. Okay? Also, under the practice direction, you must send the AR, which is the it's something like a very important. It's something that you can track on the record. Okay, so by using AR, you can check the record of the delivery status of your rig, whether it has been successfully served on the defendant by telling that on which particular date you visit his house to serve the rig. Okay. I saw one question on what is meant by concurrent read. Let me check. From the meaning itself, the concurrent is diversity lah. Actually, a concurrent rate is like this. Based on what I researched, a concurrent rate is that where the defendant has different address. So you serve it to different address on the queue. Is that okay? So we come back to this question. Okay, so I believe that when you already explain the what is a read and the lifespan, and also your application for SS, that will be your entire answer for this. Okay. Adam enter into next question. Adam enter into a lease agreement with a mall owner, namely Z Mall Berhad, to lease 10 short lots for the purpose of carrying out furniture business for a period of 10 years. Adam paid the rental for the first year of the lease. Zemo Berhad subsequently suspected that Adam may convert the furniture business into a business selling coffins, and if this happened, the image of the mall would be greatly affected, and the other tenants of the mall may not renew their tenancies. However, Z Mall Berhad has no evidence to support their suspicions. Z Mall Berhad has given notice of termination of the lease to Adam and threatened to evict him from premises. Adam wants Z Mall Berhad to be bound by the term of the lease agreement and wants a court order to speedily to compel Z Mall Berhad to comply with the lease agreement. Advise Adam on the procedure that he should adopt in the circumstances. Any thought or answers you can share in the room. Okay, actually, the answer here, it should not be interlocutory injunction because you see the question. Adam wants Z Mall Berhad to bound by the terms of the lease agreement and speedily compel Z Mall Berhad. So basically, looking into the question, right? is something like an unlawful termination, because the reason why they suspected the Adam, they suspected Adam will convert the business from a normal furniture business into a coffin selling. Okay, I'm pretty sure you all will know what is the difference between a furniture and coffin now. Okay, so that by looking into the question, Z Moore has given notice of termination of the lease to Adam, and now Adam wants him to compel to the terms of the lease agreement. So the answer for this question is purely based on Order 81, a summary judgment based on the contract. Okay, so under summary judgment, there are four types. One is 14, the general one. The general one usually is recovery of debt and also general tort actions. 14A, on the points of law. So on the question of law means that you are interpreting to the clauses of those documents. Let's say your memorandum, article of associations, or now has been replaced into constitution of the company, or the director resolution usually are the official documents. You want the court to interpret the validity of the particular documents, clause, or wordings. Because question of law is only based on the interpretation of the particular wordings. Then the third one is the Order 81, where there's a breach of contract. You want the summary judgment by compelling the other side to bound by the contract. Then the last one is Order 89. Order 89 is where you want to evict the squatters. What does it mean by squatters? The person stayed in the particular premise or particular place without your prior knowledge. Let's say you don't know a bunch of people staying at a piece of land. So when you want to do something on the land, let's say you want to develop the land, then you realize, oh, there are a bunch of people staying there. So you want to enforce it because you don't know them. Without your knowledge, they already stay there for a particular period, like 1 month, 1 year, or 10 years. So that you want to use the court order to evict a bunch of these squatters out from premises. So here are the four types of the summary judgment under the rules of court. So looking into the fact is saying that he wants to compel Z. Moore Berhad to be bound by the terms of the lease agreement, because now Z. Moore Berhad has issued a termination notice of the lease agreement to Adam. So what Adam can only do is apply for summary judgment under Order 81 to compel Z. Moore Berhad. Is that okay? Okay, so someone has asked me what is the difference between question of law and question of fact. Question of law, I will give you one scenario. Today, I scold my friend in a Zoom meeting. As I scold him as, hey, potato. Okay, after the meeting, right, he served me a rate and his claim is a defamation suit. Okay, so when it comes to this scenario, right, if looking at the question of law, it requires the court to interpret whether the word potato has a defamatory meaning. This is on the question of law. Because interpreting the word potato is a defamatory, has a defamatory meaning, and can sustain his claim for defamation. But on the other hand, when it comes to question of fact, it's merely us, it's merely looking into this, whether I have said him, whether I have called him as a potato. Okay? So this is a different thing. Question of law is to interpret the thing, whether it can sustain your law, your claim. So if purely based on question of law, it's just like, okay, the word potato carries a defamatory meaning so that he could claim you again, he could bring a claim against me because I call him as a potato, and the potato is the word itself carries a defamatory meaning. But when it comes to question of fact, it's just asking me yes or no, I have called him as a potato in the Zoom meeting. Is that okay? Okay, we move to this question. Ahmad and Harun are partners in the firm of accountants. They had executed a profit-sharing agreement between themselves relating to the division of profits. A dispute has arisen between them in respect of divisions of profit. Ahmad has filed a writ action against Harun seeking, inter alia, a declaration that Ahmad is entitled to a larger portion of the profits under the profit-sharing agreement. Harun takes the view that Ahmad has misinterpreted the clause in the profit-sharing agreement, and that dispute can be resolved. If the court could determine the real meaning of the clause, the case is fixed for trial in 2026. Harun wants a quick resolution of the dispute in court and has sought your advice on the quickest way to resolve the issue without the need to go for full trial. Actually, this is the scenario. Because you see, Harun takes the view that Ahmad has misinterpreted a clause in the profit-sharing agreement. So by looking at this scenario, the only way to resolve it is get a summary judgment under Order 14A, let the court to interpret the clause. This is the only way to quickly resolve under the summary judgment, because it wants the court to interpret the wording. Because since it's a question of law, you've got nothing to do already. You've got nothing to say yes or no, because yes, it's already in the agreement, but whether or not it's valid or whether or not it's legal, okay, let the court decide. And the funny part is that you have no limit on the number of questions of law to raise under Order 14A. Okay? Question 5. Yusuf and Raja were equal partners in the firm. They have had a long-standing business relationship with Bakar to supply building materials to them. After a while, Yusuf and Raja stopped paying Bakar for the goods supply, and soon after, the firm ceased operation. Raja's whereabouts are unknown. Bakar filed reaction against Yusuf for the amount owed to him by the firm. For some unknown reason, Bakar did not name Raja as a co-defendant. Yusuf is unhappy that Bakar did not include Raja in reaction. Yusuf is of the view that Raja should be made liable for the 50% of whatever sums due to Bakar. Advise Yusuf on the procedural steps he should adopt to make Raja equally liable to Bakar's claim. So from this question, right, you see here, this is a very, very interesting part. Because Yusuf and Raja were the partner, but Bakar only sued Yusuf. So what can Yusuf do? I saw one question of adding him as a co-defendant. Yes, it can be, but alternatively lah, alternatively lah, you can also bring a third party action, joint tortfeasor. Because adding a co-defendant, the first thing is you must make sure that you will not defeat the cause of matter. Yes, equal partners in the firm, of course, it will not defeat the cause of matter because last time they will sue them, they were in a very good relationship, shaking their hands together. But when problem arises, how come only sue Yusuf? Okay, but why third party action is also available? Because the because under the third party action, right, you can also bring an action to a defendant has the option. Because you see, to determine whether or not we want to bring the action under court, adding a court, a joinder under join by way of joinder or by way of PPP is at the option of the party. If plaintiff, he can only do adding a court defendant, but the defendant has the options to either adding him as a core defendant or by way of third party proceedings. Is that okay? Okay, we move to the next question. Razak filed and served reaction against Amir alleging that Amir had committed fraud, resulting in the losses to Razak. Amir is unable to file a statement of defense on the merits as the allegations of fraud in statement of claim lack particulars. Advise Amir on the procedure he should adopt, which will assist him to file a proper statement of defense on the merits to Razak's statement of claim. But so far as I can see the answer correct. This is on the part of further and better particulars. So what does it mean by further and better particulars? Let's say today, I can give you one example. Let's say today you were being hidden by the goods sell in 99 speed mark. Okay? You want to sue them for negligence. In your statement of claim, you only say that, oh, on this particular day, you were hidden by the fallen items in the shelf in the 99 speed mark, but without telling them which particular branch. Okay, so this is the way when 99 speed mark can apply for further and better particulars. There are so many branches. You are just telling the court that, okay, you were hidden by the fallen items from the shelf. Now, without telling them which particular branch is for. So the defendant will have to apply for further and better particulars to itemize and narrow down to the issue on which particular branch caused the tortious action. Is that okay? So the answer is Order 18 and Rule 12. And you also have to tell them on how to apply. First thing, you can write from a letter. However, if the letter was being ignored, not attended, or even the answer also not enough details, you can apply to the court under Order 32(1), which is by way of Nassau. Notice of application supported by affidavit. Okay, C. The plaintiff and defendant are both prominent persons. The plaintiff filed a reaction against the defendant for defamation. The defendant filed a defense and further filed counterclaim for defamation against the plaintiff. After pleadings were closed, the defendant applied to amend his defense and counterclaim in the following manner: inclusion of a new paragraph in the defense wherein the defendant described plaintiff as a loan shark, money launderer, head of the illegal gambling syndicate. No facts to support those allegations stated in the proposed amendment. Secondly, in the original defense, the defendant had admitted calling the plaintiff a swindler, and in his proposed amendment, he denies calling the plaintiff such a name and wants to withdraw the admission. Thirdly, in the counterclaim, defendant wants to raise a fresh cause of action in libel against the plaintiff for what the plaintiff allegedly wrote about the defendant after the rape was filed. Advise the plaintiff if he may successfully object to the proposed amendments to the defense and counterclaim. So, by looking at this kind of questions, right, it's a very good thing because they separated it into 3 different items. So we can tackle it one by one by using the subheading. So the first one, inclusion new paragraph of defense, wherein the defendant described plaintiff as this and that, but no facts to support whether the amendment can be made. No, right? Because why? Looking at the case of Yamaha Motor, first thing is whether your amendment is a bona fide. Secondly, whether uh, the characters in the suit will change. But looking in the scenario, we call the defendant this, the defendant called the plaintiff this and that without any facts to support. So this is not a bona fide application. No. Secondly, in the original defense, the defendant admitted calling plaintiff a swindler, but he proposed to remove it when during his amendment. Whether this can be done? Can or cannot? Cannot, right? Because this can be seen in this case. In this QI rule, the court held that withdrawal of the admission consciously made is not allowed. Okay, now the second one also cannot. Now we look into the third part. In the counterclaim, the defendant wants to add a fresh cause of action in libel against the plaintiff for what the plaintiff allegedly wrote about the defendant after the rape was filed in court. Can or cannot? This one can see this one the cause of action is defamation. And now he wants to add a fresh cause of action for the same thing. Allegedly wrote about the defendant after it was found in court. This is likely can be done because arising out from the same fact. Unless the claim is defamation. Now he wants to add a breach of contract. Unlikely this can be done. Okay. Now we move to here. Arik discovered his employees Halim selling infringing copies of the product. Arik is worried Halim will destroy the incriminating evidence and remove the infringing copies of the products before he is able to sue Halim. Advise Arik on the remedy and procedure for addressing such a concern. This one is very, very clear, right? Short and precise. Anthem pillar order. Under the chapter of injunctions, there are few types of injunction, but very commonly used are prohibitory. First one, which is a general injunction to prohibit someone from doing certain things. Secondly is the marijuana injunction. Marijuana injunction is to prevent someone from transferring their assets out of the jurisdiction. Let's say today, when you already apply for a marijuana injunction, when the court grants you the marijuana injunction, the order, you have to serve it to the Bank Negara Malaysia. That's why the person who kena the marijuana injunction, his bank accounts tied under BNM will be totally freeze. Means you cannot remove the money from the account. Okay, so this is the marijuana injunction, which means to prevent someone from transferring out the money now or the assets. Third one, anthem pillar order. Anthem pillar order is that you want to go into someone's property and seize the incriminating evidence. Let's say today you want to seize someone from doing a counterfeit products. Let's say a counterfeit handbags or counterfeit luxury goods. So this is done by the enforcement team to go into the premise and stop them. Stop, you cannot do anything, and seize anything. Because anthem pillar order grants them to do so, grants them the power. So looking to each of the order, right, the criteria differs. For prohibitory injunction, you must have the criteria is serious question to be tried. So by granting the injunction, there must be the court will look into the fact whether or not it is necessary to grant an injunction. Okay, the injunction itself is like stopping people from doing certain things. So the threshold is lower. So when it comes to marijuana injunction, the criteria is good arguable case. Why? Because the thing is we want to show that the let's say plaintiff wants to apply for the marijuana injunction, right? He must be able to show that the defendant will siphon out the money, like transferring out the properties to somebody else, blah, blah, blah. He must be able to prove that, show that the intention of the defendant will do that. Okay, this is so-called good arguable case. But when it comes to anthem pillar, I will say, anthem pillar order is the highest threshold. It must be a prima facie case. What does it mean by prima facie case? That means you must have your established evidence and concrete evidence showing that this bunch of people are doing have the possession of the incriminating evidence and they have the likelihood to destroy it. So, therefore, you see, the criteria of prohibitory injunction, Mareva injunction, and the anti-penal order is totally different. It the threshold is higher and higher. The highest one will be anti-penal. So when it comes to anti-penal order, right, you see, you have to explain why he must apply for anti-penal order because he is worrying Harlem will remove the infringing copies uh, of the products by Harlem. Then second thing is your procedure, order 29, this and that. But when it explaining the procedure, when it explaining the uh, contents in the affidavit, you must tell the court, you must tell the examiner that this is not serious question to try them out. This is a prima facie case. So when you're explaining it now, you must be able to tell the examiner in order to secure your marks. Okay, what are the orders that the court may make in respect of an application under Order 14 of the Rules of Court 2012? This one, we can just copy, rule up from Order 14 now, since the question already say that. You can copy pull up from your Order 14. Okay? The orders that the court, which means the directions, all the judgment given by the court. Okay, this one, state the statutes which forbid the attachment of debt. This one, got no case law, but to memorize all the statutes, like your EPF, the EPF Act, your BNM Act, those acts are like your EPF, and then what else? The Government Proceeding Act, then your BSM Act. I mean, there are numerous of the statutes which prohibits the attachment of that law. You have to memorize it one by one. Okay. Last question. The federal court, being the apex court of the country, has the inherent power to review, including the Court of Appeal decision. Okay, so by looking at this kind of questions, right, actually, as you see, it's not only purely about the inherent jurisdiction. You also must include the what is the power of the federal court, because under your federal constitution, right? Why there is a federal court? Because this is following our two-tier legal system. So by saying that your your jurisdiction of the court, right? Actually, the legal system, the two-tier legal system. So that means when your when your matter is starting from sub-court, your first appeal is to high court. Then your second appeal is to the court of appeal. But when it comes to when your matter, on the other hand, when your matter is starting from high court, your first appeal is to court of appeal. Then your second appeal is to federal court. That is the reason why federal court is the apex court of the country, which means when it comes to the federal court matters, right? Actually, when you lose, then you got nothing to do. You lose everything. Okay? But when we want to see the federal inherent jurisdiction, I mean, this also can be seen in your criminal procedure. Because in the criminal procedure, I believe they've explained what is meant by the inherent power, inherent jurisdiction by each appellate court, not only limited to federal court, but those courts has the appellate power. Let's say the High Court, the Court of Appeal. Yeah, these three courts, being the appellate court, must and will have the inherent jurisdiction. But when you want to answer this question, right, your first answer is that your Rule 137 of your Rules of Federal Court 1995, which means we stated that the inherent power of the federal court is to prevent the miscarriage of justice. Okay, so those case law you can see is where the inherent jurisdiction is to review whether the decision was correctly made or was properly made. So this is so-called inherent jurisdiction. It's not on, because when it comes to appeal, appeal is different from trial. In a trial, you call a bunch of the witnesses to go to the court and examine them one by one. But when it comes to appeal, it's totally different word. Appeal is just rehearing of that particular matter, which means that whatever you already provided in court and the judgment delivered by the judge. So whether there's any error in law and why there is an error in law, you must itemize it one by one that you have to do the appeal. So that is the reason why when it comes to appeal, you are not repeating the same trial, because you will not be calling the same bunch of persons going to the higher court again. The persons will be only presented at the first trial. So that appeal is not a trial. Appeal is just a rehearing of the matter. So it's by way of the submissions of the parties by saying that, okay, whether this is correctly done, or whether this was properly done, whether there's any error. This is what appeal will do. Even though when it comes to federal court, you are also appeal because you are bound by two-tier legal system of appeal. First, appeal to court of appeal. Secondly, to the federal court. Okay. So when you answer this question, you must be able to itemize the structure. You have to structure like this. What is the inherent jurisdiction by the inherent power by the federal court? Okay. So and also the case laws law. I leave it to you because case law might differ. Now we look into the second last question. With reference to the case law, discuss the circumstances which an appellate court will interfere the finding of fact of the trial court. So why I mean why they must why looking into the question, right? Actually, to be very honest, there is a logic. The logic behind all this is because that first thing, there is no more, there is no more trial. And when it when during the trial, the demeanor of the witness has been recorded by the previous judge. When it comes to appeal, it's a different set of judges. So the judges may not be able to see the face of the witness during the trial because they will not appear again. So that is the reason why when it comes to the appeal stage, most of the time, I would say most of the time, the judge will rarely interfere with finding of the previous judge. Although our first sentence of the appeal will say that is the error of the previous judge in the court during the trial. But the problem is when it comes to here, the actually the appellate court judge will rarely interfere lah. But there are certain principles where the appellate court will interfere the findings. First thing is whether this, I think this one also quite similar to a criminal procedure because in the criminal procedure, right, I believe you can find the principles where the appellate court judges will go and interfere. Okay? But this one, I am not sure. I think the rationale behind is more or less the same, but just that um maybe the cases will be different because my cases are very, very relaxed only for this part. But the principles are the same. Okay? Then we move to the last question. What is your advice if an application for judicial review is not made within 3 months from the date when the ground of the application first arose or when the decision is first communicated to the applicant? What is your advice? All right. Order 55, Rule 3, Sub 7. Okay, that will conclude my sessions from here.